Hey crew, I'm back and ready to jump right back in here. And we're going to go over 3 things. A clarification on the Cory announcement I made last update, a decision that was made about the Egg Juror, and a filing in the Austin Stanley vs. Will Folks case. Because they're about to have a hearing on the motion we're going to talk about, and it's about changing venue. So we're going to cover the plaintiff's memorandum in opposition to defendant's motion to change venue. And that's a mouthful. So let's get started. This is Legal Updates with Kassidy. A foiled egg, unresolved restitution, and Fitz News is the latest venue shopper. Welcome. In the last update, I mentioned Cory's upcoming hearing, and I kind of did so in passing. I mean, to be fair, I was in Lake Como at the time and didn't want to spend too much time away from the views, but I wanted to fill in those details now. There's also been a new status update since then that was filed on October 28th, so we're going to include that as well. Now, on October 7th, there was the status update that I mentioned, and it told us that the scheduling order that we'd been waiting for a long time had finally been issued on October the 2nd. Now, if you don't remember, from several months ago, Cory had pleaded guilty in federal court and was sentenced. Then, he pleaded guilty in state court, where he received a much longer sentence. That kind of changed everything, because that would mean once he finishes his term in federal prison, he would then be transferred to state prison, where he would then go on to serve many more years. So just like Alex, after pleading guilty, once he saw his sentence, he immediately filed an appeal. The thing is, his prison sentence had been decided, but not the restitution aspect of his sentence. So without that, his appeal was premature and had to be withdrawn until this restitution has been decided. So the quarrel now is over that financial restitution portion of his sentence. Now, in the judge's scheduling order, they were told that a hearing to settle this has been tentatively scheduled for December 18th. And I say tentatively because that's only if they have not worked it out amongst themselves before then. But as I said, there was another update since then, just a few days ago on October 28th. So they're now down to a month and a half to get that sorted. I personally will not be surprised if it does in fact come down to a hearing next month. Now our next piece is about the Egg Juror. I haven't talked much about this because it just irks me so much. When have you ever heard of a juror being removed for cause, hiring an attorney, and especially in this case, an attorney who's great friends with one side of the counsel? And by the way, at the time this attorney represented a client who was suing the defendant. When have you ever heard such nonsense? How does that even happen? If you're a juror who is let go for cause, you tuck your head and you walk away in shame for not doing the duty that you took an oath to do. Why hire a lawyer? Is your lawyer going to get you back on the jury? I mean, what exactly is she hoping for here? And I went back through one of my old videos today. First of all, yikes, the sound quality of my mic back then with popping pea sounds, it was embarrassing. But the video is still worth a watch. It's Dick showing up at the door of the person who sent the court an email, the very email that let the court know that Myra the Egg Juror was running her mouth. Now in this video, you hear Dick asking leading questions, but you hear this woman tell him why she sent the email. And though he tries his best to put words in her mouth and blame Becky Hill, somehow she had sense enough to record all this, and we get to hear her own explanation in her own words of what she heard and what caused her to reach out to the court. He tries to get her to say it was from Becky Hill. Then, when that fails, he tries to set up getting an affidavit from her that no one from the court bothered to follow up with her, trying to say the court did something wrong, that they didn't follow up, that they just removed Myra, because they, for some reason, wanted her gone. He never ends up going back to get this affidavit, because what the court did, there was so little time left in the trial. If you'll remember, she was excused shortly before deliberations. They were right down to the wire. They didn't have a week to hash all this out. The trial had already taken 6 weeks. These jurors had lost 6 weeks of their lives, 6 weeks of their wages, making $20 a day. This situation needed addressed by the court and handled. So what did they do? Rather than waste their time going out to this woman who sent it, they tracked down the people that she said had directly heard it from Myra herself. This woman at the door, third party. They didn't have time for that. They tracked down the people that she said Myra talked to. They were investigated by SLED, affidavits were signed, presented to the court. The court had to let Myra go. There was simply no way she could have been left on that jury after those accusations were made, especially with police cam, interviews, and signed sworn affidavits. She had to go. It had nothing to do with Becky. It had nothing to do with Facebook. It had nothing to do with anyone's ex-husband, and everything to do with witnesses coming forward and saying Myra was running her mouth while under her juror's oath. Now, I'll have that video pinned in comments for you if you need to watch it again, but that is what happened. Now, for who knows what reason, she decided to come back. She revealed her identity. She joined forces, as I told you before, with a convicted felon who stole government COVID relief funds to buy cryptocurrency with. And a quick update on that as well. That guy, James Seidel of Crime and Cask, who at times claims the book is Myra's writings and sometimes claims they're his writings, but he recently had his day in federal court as well, where he pleaded guilty and has now been sentenced to 5 years probation. But anyway, Myra gets all juiced up by Joe McCulloch and all juiced up by James Seidel so that he could make money off of a book with her name on it. And then she goes on to do some interviews and tries to stir things up about getting some in-camera hearings. Now, these in-camera hearings we've talked about before, they were sealed by 2 different judges in 2 different courts, and she wanted to just wave a wand and unseal them. For what reason? She's a disgraced juror who broke her oath and had to be removed. Why does she need these things unsealed? What is the purpose? What is the point? She wasn't removed because of Becky. I mean, does she think she'll get reappointed as a juror? Get to redo these deliberations? Get to set Alex free? I mean, I just don't understand. She had to be removed, no question. Why go on embarrassing yourself? Why reveal your identity? I don't understand, but here we are. In this latest ruling, the South Carolina Supreme Court has now ruled that these hearings will not be unsealed. I mean, it's a ridiculous ask. These sort of hearings, they're like the sidebars that the attorneys approach the bench for and speak privately with the judge. When court TV's filming, they turn away, they mute. They're not meant for us. And like I said, she had to be removed because of the evidence against her. It had nothing to do with Becky, nothing to do even with Alex. It was evidence that was brought to the court from outside people. It didn't come from internally. It came from a concerned citizen completely unaffiliated with the court or either side of counsel. And now the South Carolina Supreme Court has ruled, let it go. And finally, we come to this memorandum. And this is yet another case of venue shopping. And I dare say plaintiff's counsel does a much better job at legal reasoning for why their client should be able to keep venue in Hampton County when compared with Buster's attorneys. So we have this case of Austin Stanley, who is suing FitzNews and Will Folks. And if you're new to this channel or you forgot, the reason for this suit is that Austin Stanley's picture was placed in an article put out by FitzNews where he was labeled as a prime suspect in the murder of Stephen Smith. There was a lot of language that went with it, saying that a prime suspect is basically guilty, things like this. And I'll link those earlier episodes with all of that information as well. The thing about this one is, it didn't just happen one time. One time, everybody makes mistakes. But it was addressed. Austin Stanley's mother contacted Will Folks and FitzNews and said, hey, you got the picture wrong. This is my son. He is not a prime suspect. He's not a suspect in any kind in the murder of Stephen Smith. She did receive a reply, she was promised it would be corrected, and yet somehow, several months later, it happened yet again. Austin Stanley's picture put up again, prime suspect in the murder of Stephen Smith. Hampton County is pretty small. People know each other. Most people have heard about the murder. Imagine seeing your face with the words prime suspect underneath for one of the most talked about murders of their time. It's not a good feeling. Walking down the street, people have seen your picture there, seen you called a prime suspect in this murder. Now, defendants, which is FitzNews and Will Folks, have filed a motion to transfer venue, and they want this case to be heard in Richland or Lexington County. So this document is put out by plaintiffs to oppose this move. Now we see in background, and a lot of this we covered before in the initial complaint, Austin Stanley is a resident of Hampton County. It's where he lives. The murder of Stephen Smith, guess where? Hampton County. Now, defendants were trying to say because their business is not Hampton County, that Hampton County is the wrong venue. So this document is all about why that is not true. One of the things they mention is that this action was commenced against the defendants in Hampton County on or about February the 6th, some 6.5 months ago. Defendants answered that April the 12th. And we've got a nice little timeline here. Back on February 26th, plaintiff was served with his first set of interrogatories, his first set of requests for production, and his first set of requests for admission. Going down through the timeline, April 25th, defendants served responses. On April 25th, plaintiff moved the court to compel full proper responses, and we had an update on that. On May 3rd, defendants answered plaintiff's first set of discovery. The plaintiffs responded to that on June 28th. Defendants served supplemental responses on July 8th. There was a court hearing on the motion to compel on July 10th. We also covered that. Defendants then served their second supplemental answers to plaintiffs, their first set of interrogatories, and their second supplemental responses to plaintiffs' first set of requests for production on July 22nd, 2024. So after all of this took place in the Hampton County Courthouse, not just documents filed, but even this hearing, 6.5 months later, on August 22nd, defense moves for a transfer of venue. They state that Hampton County is the place where the publication complained of was communicated to others and the place where reputational harm of the plaintiff occurred and continues to occur. And that makes sense because that's where he lives. That's where he's known. Many residents of Hampton County who recognize the plaintiff's photograph have commented to him, his family, friends, and others about his alleged involvement in the murder of Stephen Smith, damaging his reputation and standing in the community. Part 3 goes into why Hampton County is the proper venue. It explains what this tort of defamation allows for a plaintiff to recover for, and that is the injury to his or her reputation as a result of the defendant's communications to others of a false message about the plaintiff. So the focus of defamation is not that somebody's feelings are hurt, but it's about the injury to that person's reputation. The gravamen, which is the serious part of a complaint or accusation of a defamation action, is the communication of the false statement to a third party or injury to reputation. So it's all about the injury. And where did that injury take place? Yes, it was seen around the nation and around the world, but as far as the actual injury, wouldn't that be most seriously felt where Stanley actually is? And that's the first thing I thought of while reading this. If this article came out in Colorado or Rhode Island, he might not even be aware of it. Your reputation exists where people know you. Where do they know him? His hometown. Doesn't that make sense? It cites a case, Fox v. Smith, and this was heard in the Supreme Court of Pennsylvania. This was a case of libel or defamation, and the issue was about the location of where the so-called publications of the statement occurs in an internet-based situation. The old laws on this dealt with more localized things like newspapers, but now we have the internet. So new laws had to be formed. So how the court explained publication in this case, they said it occurs where a statement is read by a third person and understood by that individual as being defamatory. It goes on to say that the most important function of an action for defamation is to give the innocent and injured plaintiff a public vindication of his good name, restoring his unjustly tarnished reputation, with the definition of reputation being the estimation in which one's character is held by who? His neighbors or associates, the people who know him. Additionally, the mere fact that the publishers may not have specifically targeted residents of a particular county in disseminating their accusations lacks essential relevance. It's about where this harm or injury would take place, not about where this was sent out. The next paragraph goes on that in order to appropriately balance the interest of plaintiffs in restoring their reputations in forums in which they've been damaged with the ability of defendants to ensure that selected venues are meaningfully connected to the disputes. And it repeats this phrase again, publication occurs where a third-party recipient receives and understands the statement as being defamatory. So when a person is defamed via a medium with worldwide accessibility, like the internet, a plaintiff may select a single venue in a defamation action in any location in which publication and injury has occurred, albeit that publication and harm may have ensued in multiple locations. It then lists a case, Gaetano versus Sharon Herlad, where this was cleared up. It says when one speaks of the publication of a newspaper, we think of the actual plant where it is physically printed and published, but this in itself has nothing to do with the publication of a defamatory statement contained in the newspaper. And then it uses an example. Say a newspaper is published and circulated in New York City. It includes a defamatory statement against a person in Scranton, Pennsylvania, but no one in New York recognizes the article as applying to the individual defamed, or there is such recognition of identity, but no realization that the article is defamatory of the person in Scranton. What do they decide? There is no publication in New York City. However, it goes on, if a few copies of this newspaper published in New York City are sent to Scranton and they're read by the Scrantonian's neighbors or associates who recognize the reference to him and reasonably believe that this is defamatory, then the newspaper has libeled him in Scranton and not in New York City, the place where the newspaper is printed and primarily circulated. And we'll expand on that in a minute. It lists another case, Lowery versus McBee, where the District Court of Appeals in Florida said that a Facebook post cannot be libel until it's published and accessed, rejecting the defendant's claim that what mattered is where the statement originated. So according to these cases, Hampton is the rightful place. They go on to say that the defendant is liable for where the tort took place, or where the harmful effect of the defendant's acts first took effect. So in this case, there was no injury until this defamatory Facebook post was published and accessed. And then they compare it to this case, saying that the venue is proper in Hampton because the most substantial act that gave rise to the plaintiff's defamation claim, in fact, occurred in Hampton, where the defamatory statements were read and seen by others. It then points to the South Carolina Code that states that venue is proper in the county where the defendant resides or has its principal place of business, or where the most substantial part of the alleged act or omission giving rise to the cause of action occurred, and that was in his neighborhood, and that the venue under the statute is proper where the plaintiff's reputation was harmed. Mr. Stanley's reputation was harmed in Hampton County. And this makes sense. We simply don't have reputations that can be harmed in a place where we're not known, because since we're not known there, we don't have a reputation there to either be good or bad. If I went downtown right now and started screaming, Austin Stanley is a prime suspect, no one would know who or what I'm talking about. The only place your reputation can be harmed is where it actually exists. And Mr. Stanley's reputation exists in Hampton. These stories, posts, and online videos were accessed and read by Mr. Stanley's friends, family, neighbors, and community, all in Hampton County. And the gravamen again of this claim is injury to reputation. Part 4 mentions something that was already touched on. When venue is proper in more than one place, the plaintiff's choice of venue controls. So anywhere that people might have known him and saw this, yes, that's defamation. But when it's in multiple counties, it's plaintiff's choice where he wants it held. And think about that. He lives in Hampton. The damages occurred in Hampton. He chose Hampton because Hampton is where he needs his reputation restored. And the bottom line is it's his choice. I mean, I think any of us, if we were accused of murder, if our faces were plastered out there not once, but twice, you better believe you want it cleared up where it's your neighbors and people who actually know you, people who see your face. That's who you want it cleared up with. Not a few counties over where you may or may not go and where people may or may not know you. You want it cleared up where you know people and people know you and know your face and know your name. And that makes sense. It then goes down to Rule 12, and this is about the timing of this, and that when you let too much time go by, you're actually waiving your right to try to change venue. They're saying not only has it been 6.5 months, but they've been engaging in substantial litigation. And I told you this would come up again. We went through the timeline of all the documents that were filed, that a hearing had taken place, and here's a case, Landvest Associates versus Owens. And there's this protection of Brown, Witherspoon, and Harmon that you don't automatically waive your rights. But as in this case, too much had gone on, too much time had passed. They were no longer under the protection of Brown, Witherspoon, and Harmon. And they're comparing it to this case as well. And yet another case, Henley v. North Trident Regional Hospital, the court found waiver where the defendant served interrogatories and waited 3 months after answering and 5 months after service before pursuing its right to change venue, with the Supreme Court listing failure to claim the right within a reasonable amount of time. So this was 3 months and 5 months, but this case, it's over 6.5 months. So they're saying that because they didn't make a timely motion or move for change of venue, substantial progress and work had occurred in the case, that as such, they've waived any right to seek a transfer based on residency, and the motion should be denied. And they go on to request the court to deny this motion to transfer venue, and refer to previously filed affidavits. And this was submitted by Mark Tinsley and Brendan J. Green on November the 1st. I started this update yesterday, but I didn't get it finished last night. And so in the meantime, there was a hearing held this afternoon at 2 p.m. all about this motion. After hearing both sides, Judge Bonds made a determination about the waiver portion, stating that the case is from 2024, so he was not prepared to rule that enough time had passed to say that they had waived their right to file a motion for change of venue. For the rest of the decision, dealing with the argument of publication as a basis for a reason to remain in the Hampton County Court, he said that with the cited cases all having taken place outside of South Carolina, he needs to do further research on these cases before he makes his ruling, and that we can expect his ruling by the end of this week. I will definitely be keeping my eye on that to update you as soon as I hear something. So that brings all of our updates to a close. Thank you so much for not giving up on me while I was gone. And as always, I'll keep my eye open for any developments that may come in any of these cases that we're following. Till then, this is Kassidy O'Connell saying stay well and stay tuned.